Hi there, welcome back to part 2. Sorry, we can only record 10 minutes on YouTube, so back to the Dworkin and Hart debate, okay? So people using the law under Hart's legal theory would not be communicating, but rather just talking past each other. By putting Hart's legal theory in the same category as a plain fact positivism, Dworkin is basically suggesting that Hart's theory allows the court to accept facts when forming the rules of recognition, or as Dworkin would call it, the master rule. Okay, and the criteria of legal validity must have the specific kind of plain fact, also known as predigy matter, that concern how law is created. Now, aside from the external point of view and plain fact positivism, Dworkin also misrepresented Hart's theory for lacking moral principle. Dworkin's main argument was that for Hart's theory to have moral principle, it would have to sacrifice its core tenet. This is a mistake because Dworkin ignored Hart's acknowledgement that the rule of recognition may incorporate as criteria of legal validity with a moral principle. In his work, Hart depicts that many connections between law and morality. There can be a harmonious existence between law and morality without sacrificing its core tenet. Dworkin's rules differ from that of Hart in two ways: all or nothing rule, normative rules, and the ill distinction between rules and principle. Well, first, the all or nothing principle suggests that there is only one rule, one particular principle of our law, and this principle directs social officials towards that principle. So in any hard cases, there is only one correct answer, one absolute truth. Okay, Hart, however, viewed the rules quite the opposite. According to Hart's legal system, the rule of recognition, the union of both primary and secondary rules, is needed in order to provide tools of legal analysis. These rules could be in disagreement and still provide a correct ruling. So they do not require following that rigid rule of all or nothing. Hart argues that the principles often have conflicts and rules sometimes collided with each other. When that happens, a further rule is required to regulate the conflict. Hart goes further to explain the need to be tolerant of a margin of uncertainty so that informal judicial decisions can be made. Being not restricted to an all or nothing principle, there is flexibility in the legal system to not only have a healthy debate and conflict, but also to give the judicial system a chance to rationalize settled decisions and issue of the statement. Okay, another area of the rules where Hart and Dworkin differ is the normative rule. Dworkin believes that with a normative state of affair, one can provide form to a normative rule. This normative state of affair is where there is the existence of good moral ground or justification for doing what the rule requires. Hart provides an analogy of this normative state of affair by using religion. He argues that it is a regular practice for a churchgoer to remove their hat in church. This practice cannot constitute a rule which justified by creating ways of giving offense. This state of affair, which allows normative rules to function as a rule, is far too strong for Hart. Hart described the rule as custom-type rules of social community. Rules are not only conventional social practices, but rather they are a set of general accepted rules that is functionally important because they establish duties and reasons for Hart. There is conformity to a group when their members accept these social rules. The established law and social rules have been established long ago. People follow these rules because it has been generally accepted by society. Dworkin argues that Hart ignores the distinction between rules and principle in enfeebled legal theory. Hart placed no emphasis on the application of principle into rules. The rules may may or may not hold fundamental principles. It is different from Dworkin, where principles are a set of moral and value system. The principles identified are not only a part of the theory of law, but are also implicit part of the law itself. It is the general part of adjudication, and is the silent prologue to any decision at law. Dworkin describes the difference of law principle and rules. Legal principle carry a dimension of weight, but has no validity. Thus, the legal principle come in conflict with another principle of greater weight. The weaker principle may be put aside and will not be used to determine a decision, but may be used in the other cases where it has greater chances of winning a case. Rules, in contrast to principle, are neither valid nor invalid, and they do not carry the dimensional weight. If any rule comes in conflict, one rule can be valid. Under a legal system with Hart, law as a system of rules has failed to take into account principles. Hart does not agree with the sharp contrast between legal principle and legal rules of Dworkin, nor does he agrees with a valid case will always be determined to determine the result of a case. So, principle can bring special components to a legal theory, where rules alone cannot bring. If Hart were to have any principle in his theory, he would have to abandon his rule and theory. So, legal principle, according to Dworkin, cannot be identified by criteria provided by a rule of recognition manifested in the practice of the courts, and since principles are essential elements of the law, the doctrine of rule of recognition must be abandoned. The Hart's rule of recognition must be rejected and abandoned because they lack principle and usefulness. The rule of recognition are not complicated. Is not a complication of Hart's primary and secondary rules. These rules, as mentioned previously, are not useful because they have no substance. They have taken an external point of view of the law and not an internal point of view. These rules are just a bunch of rules passed down without any principle or morals. Dworkin argues that this theory of values must be abandoned because it cannot accommodate a wide range of disagreement in the word of law. This theory would permit a process of identifying laws with great controversy. When hard cases are presented, a judge would have disagreement amongst themselves on the legal theories. It is this division amongst judges that gives an illusion of generally accepted laws which are uncontroversial. Once we have abandoned the Hart rules of recognition, Dworkin suggests that it should be replaced with a system of rules that have principle, an external point of view. He proposed that legal principle can only be identified by constructive interpretive as a member of the unique set of principles. Basically, for a legal system to function properly, there has to be a special set of principles which are used as interpretive tools to identify legal principle. Hart's system lacks principle and is thus not useful. Morality plays an important role in Dworkin's view of nature of law and as an important element of Dworkin's legal theory. They are the guiding principle of legal theory. Even though Hart says that there is no connection between law and morality, Dworkin argues that there is a connection, and law is an interpretive concept that requires judges to give judgment to a legal dispute in a just and fair manner. A just and fair legal system is dependent on the judge's conviction to a set of principle and a political morality. With a set of morality or set of moral principle enacted to a legal system, Dworkin insists that judges do not have a strong discretion, and even in hard cases there is only one right answer. Judges have previously decided on cases with related problems, right? These decisions are part of a long story that judges wrote, and judges must interpret and continue, using his or her own judgment in making the theory story better. So, next I want to talk to you more about this, but let's tune in later on in part 3 of this Hart and Dworkin's debate. Thank you for listening.